very carefully by the tribunal, because the power that is there is very vast. It's not given as to if this condition is there, then you can wind up the company. So since that discretionary power is there, that power has to be used sparingly and under those circumstances where it is necessary to do so. Okay. Now coming back to circumstances in which the company may be wound up by the tribunal, and you had a question. Okay. Now before I answer your question, I have a question for you, and I want you to take few minutes and try to give me the answer for the question that I have, and then I'll answer your question as to if there is a cap for winding up of the company under that first provision that is there, which is given. Okay, I've got a particular set of facts that are there before you. I want you to go through this very carefully and tell me what are the concerns and the issues that are there. Okay, what are the things that are there which you will want to consider, or what are the things that you will keep in mind to decide whether a company should be wound up on the given set of facts. Okay. The problem is that there is this company ABC Limited, it's a public company. Okay. So it was incorporated in the year 2001 and it has its registered office in Mumbai. The company has issued 5,000 bonds. All of you know what bonds are. So it's issued 5,000 bonds of rupees 1,000 each. There's this person Ratan who is a director of company X, and company X is also a small manufacturing company, and it is doing the same kind of business that XYZ Limited is into. So Ratan has purchased 20 bonds from the company XYZ when it issued the bonds. Now for some reason, the amount which was repayable by company ABC Limited within 12 months, it was not in a position to repay that amount. Ratan wants to file a petition under section 433B, that was the provision under 1956 Act, or if you are looking at the 2013 Act under section 271, it wants to make a petition. Should the tribunal entertain the matter? Should the tribunal take up the matter? What are the concerns that are there, and why are those concerns there in your mind? I don't mind you discussing amongst each other. You can have a group of 4, like I usually say 4 or 5, and you can tell me what are the different things that you will keep in mind, and what are the different things that you would want to know. When you talked about, you asked me the question as to if there is a cap, look at this and tell me, you know, whether you would want to accept this petition and order the winding up of the company. Okay, just let me allow people to think about it also, but I'll ask you the first question. Okay, then I have you also. I'll come back to you. As a company which is to be wound up, what are the problems? Sorry?
71 section is winding up by the tribunal, right?
Yeah. 433 is winding up by the tribunal. Both are the same. I've just brought both the sections together because anyway both are applicable. Okay, you have some answers with you. Okay, let me start from here because he raised his hand first.
I can't
Okay, that's right. Winding up is not a process through which you are recovering debt. Okay, you wanted to say something.
Actually depends on whether it is defaulted on various other basically
Various other?
various other creditors because the Hindu bond has been get 5,000 bonds for very
Okay.
so it actually depends that if it has defaulted on other bonds as well.
Okay. So 20 bonds means about 20,000 rupees. Okay.
So if the company is defaulted on other bonds as well, then the creditors can go to class action and then they can ask for winding up.
Okay.
Because if X limited goes paying 20,000 rupees, I don't think it's a viable
Okay. Yes. Okay. Okay. I found 2 points over here, okay? And I want you to note down these points also, the different things that are there which are being spoken about. There are 2 different things that have been put forth by the 3 people. You wanted to say something.
The first thing would be that how long is it lapsed for? And like Purkit said, that was the point that I was going to make, saying that has he taken any other measures to try and recover this money?
Okay.
Now, apart from that, the question would also become, is the company just not pay the amount or are they unable to pay the amount?
Okay.
So it also depends on the liquidity status of the company. If they are able to pay the amount, then a civil action suit would just get to your money.
Okay, okay. Yes. Oh, okay, okay. So commercial insolvency is something that you're going to. Mm-hmm. Okay, okay. So I've got 4 points now that is there which I have tried to get from here. Yes, what do you think? You've heard the others, so do you want to add on something or do you strongly want to, you relate to one of them? Okay, anybody else? Yes. Yes. Okay, okay. It doesn't make sense. Okay, I think, yes.
Would the court also look into the matter, like what was the bond contract between the 2 people?
Okay, which I have already said over here, isn't it? That the amount was repayable by the company within a period of 12 months.
Would it also have clauses in it saying that, okay, if it defaults between this much interest to it?
Okay, yes. There may be other provisions that are there which is given which says that if I don't return it within so much time, then we will pay so much of an interest that is there on the amount. Yes, it can be there, and the court will definitely look at all these factors that are there. as far as the terms and conditions for the issue of the bonds are concerned. Yes. Sorry, I didn't hear you. Necessary for? Yes, of course. If a company is supplying certain essential services that are there, then closing down the company would definitely not be the most appropriate action that can be taken. Yes? Okay. Yes.
Ma'am, anyways, first of all, these are only 20 bonds. Even if it was only 5,000 bonds, the tribunal's first means of repaying that is not winding up with the company, because they will still give the company a chance to pay or help the company, or to put some fine on the company to repay that in any other way. So for 20 bonds, applying for a winding up of the company is anyways not acceptable by the tribunal. There could be any other means by which the tribunal.
Okay. Now let's just try to analyze all what you have said. Let's just put them together and see what are those relevant considerations that are there that we need to keep to decide whether to accept an application or not. I think the first consideration that has to be looked at is what is the value, what is the amount that is there, and I think that's what was the first concern that I could read from what you were saying. It's only 20 bonds, it is only worth 20,000 rupees, it's not worth to close down a company. Then you said that if there were more than 20, if all the people had come together, all the creditors had come together, then in that case maybe there was a claim that could be there. Then you also said that if there is any other remedy that is available, then in that case you have to look at those remedies that are there. Maybe you file a civil suit that is there for recovery of the amount rather than close down the company, because like all of you wanted to put it, that closing down of the company is not the option that is there. Closing down the company is not a remedy that is there, and I think what we saw over here was that 20,000 rupees, asking for a company to be closed for not having paid 20,000 rupees may not be a very good solution under the circumstances. Now if you look at the Companies Act, if you look at 1956 Act, or if you look at the 2013 Act, in both this there is a cap that is provided. Okay? The cap that is provided both under 2013 as well as 1956 Act is that if the debt is over 1 lakh rupees, then in that case you can make a petition for winding up. Now see, you can't have it on a case to case basis and say that 5,000 is a big amount in this particular case, 20,000 is big in this amount in this particular case. There has to be some statutory minimum that has to be stated, and the Companies Act says that if you have a debt of 1 lakh rupees or more, then in that case it gives you a right to make a petition under this particular provision. Now before the 2002 amendment to Companies Act, the Companies Act stated that if you had a debt of 500 rupees or more, you could make a petition for winding up of the company. Now just look at it, 500 rupees somebody has not paid, and the company has not paid someone, and the person is asking for the winding up of a company. It doesn't really go well. It doesn't make sense to close a company which has been there. The liquidity that is there with the company, what you said, is the company in a position to pay the money? It's not paid, that is one thing, but is it in a position to pay is also something that has to be considered, right? So these are different things that are there which we need to look at when we consider a problem like this. So if there's a problem like this where it says that someone has a debt to be recovered from